The information provided on this show does not, and is not intended to, constitute legal advice. Instead, all information on this show is for general informational purposes only. The information provided is not a substitute for legal advice, and we recommend viewers consult an attorney for specific legal matters.
Homeowner gets a letter, not a warning, not a conversation, a lawsuit over something small, maybe brown grass, maybe a fence.
This post right here is clearly on my site.
Maybe a parking space, and suddenly they owe $10,000 in legal fees before they even understand what happened. But here's the twist. In Florida, many of these lawsuits should never have been filed in the first place, because the law actually says you must try to resolve the dispute first through mediation. Yet every year people skip that step, and it costs them time, money, and sometimes their entire case.
Good morning and welcome to Condo Craze and HOAs. I'm Karen Curtis with attorney Eric Glazer. We're here every Sunday at 11 a.m. taking your calls and answering your questions in the chat about anything that makes your life in your condo or HOA absolutely crazy nuts from day to day. And today we're talking about HOAs, right?
Yeah, good morning, Karen. And today we're talking about one of the most misunderstood parts of HOA law in Florida, and one that can destroy your case before it even begins. And it's simple. And we spoke about this many times on the show. Before you run to court, you might be required to mediate first, and I was always in favor of that. And if you skip that mediation first step, your lawsuit can be delayed, dismissed, or become dramatically more expensive than it needed to be. And Karen, this is one of those issues where people think they're doing the right thing, and they accidentally do the exact wrong thing.
And you're saying that people actually hurt their own case by going straight to court.
Yes, they do, Karen, exactly. They hurt their own case. And the Florida legislature made this crystal clear in the statute. Okay, right now the statute literally starts by explaining why this system exists. And it makes sense. It says alternative dispute resolution, like mediation, helps reduce court cases and provides a more efficient and cost-effective way to solve disputes. Totally agree. In plain English, before everyone hires lawyers and burns money, what's the Florida legislature saying? Try to resolve the problem first. And the law actually divides HOA disputes into 3 different paths. And this is where people get confused, and here's how it works. Before doing anything, ask one simple question. First, do I need mediation, arbitration, or can I go straight to court? Because the answer changes everything. So let's start with the first category. If the dispute involves board elections or recalling board members, you can't mediate this. It does not go to mediation first. Why? Because those disputes go straight into arbitration, usually through the DBPR, or it can go directly into court. And arbitration has teeth. First, it starts off with a filing fee, and usually it's a few $100 just to start. And here's the big one. The losing party pays attorney's fees and costs. So if someone files a weak election challenge, and this happens all the time, they can end up paying not only their own attorney's fees, but the association's attorney's fees.
So election disputes get mediation entirely. I mean, mediation is binding, or excuse me, arbitration is binding, but you can appeal. So you're going to skip anything with election disputes, mediation.
Right, exactly. With election disputes, no mediation. It's got to go right to arbitration or court, straight to arbitration. That's category 1. Now, here's where the majority of HOA disputes can potentially fail, and this is the one where most people make the mistake. Most disputes in homeowner associations require pre-suit mediation, meaning before a lawsuit is filed, both sides must attempt mediation. And this applies to disputes involving the most common things. For example, use of property, covenant enforcement, changes to the governing documents, board meetings, membership meetings, access to official records, basically the day-to-day operational conflicts in communities. Those are the ones that are going, again, right to mediation. It isn't optional. The law requires it, period. That's the bottom line.
And you should know this. What actually happens in mediation? Do you need to hire a lawyer?
No, it's not mandatory that you hire a lawyer. Absolutely not. But I've been, serving as a circuit court mediator appointed by the Supreme Court for, I think it's 15 years now in the process. I truly enjoy it. I like it just as much as litigating cases, quite frankly, if not more. You feel good when you settle a case.
It's more fair because no one's happy.
Right. I always say, if at the end of the day both parties walk out feeling miserable, a good result was achieved. But both sides meet with a neutral mediator. The goal is to resolve the issues, again, without litigation. Save time, save money. Try to get the case settled on terms you could live with, and don't leave your fate up to the hands of a judge or jury. We always, we think our case is good, but the truth is you never know. But two things about mediation are important. Number one, it's confidential. Number two, it's privileged. It's just like when you get arrested, nothing you say here can be used against you, or what you do say can be used against you, but in mediation, it can't be used against you later on in court. Why? It allows people to talk openly. It allows people to work towards a solution. And you'd be amazed at how many cases settle right there. There's a reason that Florida created this system. And I will tell you that I would estimate, certainly in the cases that I mediate, I would say I have about an 80% success rate. I'm not saying it's not just me. I would think a lot of mediators can claim an 80% success rate. But, years ago, associations would sometimes sue homeowners immediately over small things. We spoke about this when we were challenging House Bill 657. Owners would get sued over landscaping. They'd get sued over garbage cans. They get sued over parking issues, really minor violations. Or fines, right? And those homeowners suddenly face thousands of dollars right off the bat. Before it went anywhere, they faced thousands of dollars in legal fees. And the legislature looked at that and said, wait, this is insane, right? We can't let this keep happening to people. So what did they do? They created mandatory mediation. And what happened? The truth, most of these cases now, most of these disputes, as it's referred to in the statute, they get resolved quickly. They get resolved economically without massive legal bills. The unit owners and the association are not leaving their fate up to a judge or a jury. Like I said, sometimes you think, many times in my career, I thought, I can't lose today. And you walk out like, how the hell did I lose?
Yes. Oh,
you never know.
Right?
But again, no, not everything requires mediation, not everything. Some cases can directly go to court. But these types of cases that can go directly to court typically involve money disputes. For example, what can't you go to arbitration about? Collecting assessments, collecting fines, enforcing previous mediation agreements. In these cases, litigation can start immediately. You can go to court immediately, right off the bat.
So it really depends on what the dispute is about. And if they're not following the mediation decision, then you got to go to court.
Then you got to go to court, exactly, to enforce the matter.
Yeah.
Exactly. And this is the part, quite frankly, people miss, Karen. You would think that attorneys don't make these mistakes and they wouldn't start off in the wrong place, but they often do.
Well, it's a little bit confusing.
Yeah, I'll file a motion to dismiss saying, wait a minute, you ran off to court, but you forgot to mediate first. But if you choose the wrong path, the entire case can unravel. And there's another important detail that people overlook, and it's when you file for arbitration, or if you serve a demand for mediation, the statute of limitations pauses, it stops. That means the clock stops running on your legal claim, and that can make the difference between preserving your rights or losing them completely. So we'll simplify this, okay? We'll break it down simple. If the dispute involves board elections or recalls, you're going to arbitration. Can't mediate that. If it involves, like most other go into mediation first. If it involves money disputes or collections, you're going to court. And if you screw this up and you ignore these rules, you ignore these guidelines, you risk wasting time, money, and leverage before your case even starts. And by the way, paying the other side's attorney's fees. And here's the practical advice. Before taking any action in an HOA dispute, ask one simple question. Stop. Ask yourself, am I required to mediate or arbitrate first? Check the statute, because if you get that question wrong, everything that follows from that point can fall apart, and it can be costly. And unfortunately, we see that. I can tell you as an attorney, I see that happen all the time.
And if you go to court, the clock doesn't stop like it does.
That's correct. That's
so
right.
That's a problem. And it's really important for both homeowners and board members to understand all this. I mean, you have to. Crucial. Especially the board members, their attorneys should know what's going on.
They should, but it doesn't happen all the time. And if anyone is curious about what happens inside a mediation room, a lot of people have never gone before. So it's a much simpler process, much more relaxed process, certainly than a courtroom.
You go back and forth, don't you? They're in different rooms?
It's funny. Technically, yes, you go back and forth, but it used to be in person. And now it's all by Zoom.
Oh, right.
You're not in a courtroom. There's no judge. And usually it was a conference room, but now all by Zoom. And you have the homeowner. You have a representative from the association there. You have their attorneys all on the screen. You have the mediator. And after allowing the parties to make opening statements, I simply break them out into what's called breakout rooms on the screen. So I can meet with some of the people some of the time, the other people the other part of the time.
That up.
I can meet with everybody. Oh, oftentimes I do screw it up.
Oh, God.
Right. But
I didn't want you.
But it works so well. But understand, as a mediator, I'm not there to decide who wins.
No.
I can't make a final decision.
They agree.
They agree. My job is to help to facilitate, the word is facilitate, a settlement that both sides can live with, find a solution. Everybody meets together, typically briefly in the beginning. I let the parties make their opening statements, typically through their attorneys. Then we're going, like we said, we separate different rooms. And then my job is to go back and forth between the rooms until we get a settlement down on paper.
And if they don't settle, goes to court.
If they don't settle, right, then they can take the next step. But my goal over the, how long it takes is to keep closing the gap, and you'd be surprised how often it works, because we certainly talk about it at mediation. Hey guys, if you don't settle today, do you have any idea what a lawsuit is going to cost if we don't get it done right now? And typically that fear that your mediator should put into the parties over that helps get the case done. And mediation typically takes somewhere in the neighborhood of 3-4 hours. Sometimes it takes a whole night.
Oh, God.
I've mediated many cases into the wee hours.
Oh, my gosh.
It just goes on.
I mean, especially if it's over garbage cans. I mean,
well,
come on.
not cases like that. Complex commercial litigation
but I mean,
cases
get over it,
can go on forever.
Yeah.
But here's what we're going to do. We're going to take a quick break. We want to hear from you. If you've been through mediation before, especially, call into the show. Let us know what your experience was like. Let us know if you think it was better than actually going to the courtroom, into a courtroom. I can say I've been in both places many times. No question you want to start out in mediation whenever you can. And by the way, if you're actually in litigation, no case will ever see a trial without going to mediation first. That's how it works. So give us a call right now, 717-452-9378. Again, 717-452-9378, or drop us a question or comment in the chat box on YouTube, and we'll be back right after this.
There are very large management companies and there are very small management companies. And I think Affinity sits somewhere in the middle of that, where they are big enough to provide you with all of the back of the house services, the accounting, the infrastructure, the support systems, but small enough to be high touch.
We believe at Affinity that we do the 9 to 5 so that you don't have to do that.
Feeling overwhelmed by repairs, renovations, or big construction projects? You weren't meant to do this alone, and you don't have to. At HCMC, we take the stress off your shoulders and guide your community every step of the way. We bring everyone to the table, owners, contractors, architects, engineers, and make sure every penny spent is done responsibly. Led by Sam Hodge, 40-year expert in construction, we manage everything from design to closeout. No more guesswork. Just expert guidance you can trust. Take control of your project today. Visit hodgecmc.com or call 954-805-5235.
Welcome back to Condo Craze and HOAs. We have a lot of people asking lots of questions because you covered a lot of ground.
Yeah, before we do that, though, I just want to tell one funny story. You remember a couple of weeks ago, we were talking about House Bill 657
Yes.
and how we think mediation should stick around and what an insane bill to try to kill it because it works so well.
Right.
And you may recall there was an attorney by the name of Dan who called in and said, Eric, I agree with you completely. The thought of getting rid of mediation is insane, right? Totally doesn't make sense whatsoever. So I wind up speaking to Dan the other day, and he says, hey, it was me that called in. He says, it's funny. I take my kid every Sunday to Hebrew school, and I wait online to pick him up. And as I'm waiting online, I'm listening to your show. So I listen for the first half hour, but all the time my kids get in the car and say, do we have to listen to that man again?
At least they don't go then that crazy woman.
Yeah, he cracked me up.
That's hilarious.
Hey, before we continue, we want to welcome a new sponsor to the show, and that sponsor is Better Call Steve Plumbing. And if you ever dealt with plumbing issues in a condo or HOA, you already know these are not your typical residential jobs. You're dealing with stacked units, shared plumbing systems, aging infrastructure, and problems that can affect dozens, sometimes hundreds of residents at once. And believe me, it requires a company that really understands large-scale building systems and really the very unique operational challenges of community associations. And that's where Better Call Steve has built its reputation. They actually specialize in handling everything from complex building plumbing failures to large building-wide projects while coordinating with boards, property managers, and residents to keep disruptions, I should say, to a minimum. And that's why we're happy to welcome Better Call Steve Plumbing as a sponsor of Condo Craze and HOAs. Give them a call if you need a plumber. Thank you for your help in making this show possible. And all right, let's get back to the show.
So a lot of people are asking questions in the chat. Does mediation also apply to condos? We're talking about HOAs.
Yes.
So they want to know.
So it's not mandated off the bat for certain things like condos are. Most of the time,
ask for it.
Arbitration, is mandated, but not mediation like in HOAs. Totally different. Why? I don't know. There's just this, the statute treats these types of disputes differently, and it just makes no sense. There should be one rule that covers both condos and HOAs, but for whatever reason, there is countless statutes that treat one type of community one way, another type of community the other way.
Why can't it be homogenous?
And
I don't
all
get
it does is create confusion, even amongst the attorneys. It's awful.
It's
And it
confusion
really
on
needs to-
top of confusion.
Correct.
Because it's
That's
already
a great way of
confusing
putting it.
for
Confusion
HOA.
on top of confusion.
And then,
Exactly, Karen. You're 100% right. Robert, I don't know if I'm hearing things, so maybe we might have to take a question from the board instead. What do we got?
So, if you know it's heading to court, you shouldn't unveil your hand either, your evidence, right?
Well,
in
if you know it's
mediation.
heading to court, but when we're heading to court, what do both sides have to do? And right now, there's a big change to the way Florida attorneys practice before 2 years ago, let's say, and now you have to automatically reveal what you have now, basically right off the bat.
Okay.
You got to reveal your witnesses. You got to reveal what documents you have.
So
you basically got to reveal your evidence right off the bat. There's no secrets. The idea being that by the time you get to court, there is no secrets.
It's not like criminal
springing
court.
evidence. You're not springing evidence on the other side at the last minute.
And
not going to happen.
What happens if the mediator admits he's friends with one of the attorneys?
Okay, if that happens, and that happens all the time, by the way. Why
you're
do you
know
think?
People.
Yeah, right. I mean, why do you think? Well, I'll tell you a funny story. How about in court one day, right? I was appointed to be, let's say, a receiver kind of a corporation, right? And one of the attorneys said that I should be recused. Why should I be recused? Because I was friends with the other attorney, with one of the attorneys in the case. And the judge answered, well, if I were to recuse attorneys from cases because they're friends with other attorneys, we'd never have a situation where we'd have a full courtroom with attorneys in it. I'd have to recuse everybody.
So, and this was in mediation?
Yes.
Because anyway, you just want them to decide. You're not making any recommendations.
That's true. And most of the time, unless the judge appoints the mediator, most of the time the parties are agreeing on the selection of the mediator.
Right.
So that's typically what happens. The parties have to agree on it.
Okay. Okay, so a homeowner has faulted on HOA payments and took the HOA to court. So that's money.
That's money, correct.
It was settled in
that goes to court.
It was settled in mediation to save fees. So I don't understand what's happening.
Okay, so
now the owner feels he won, but he didn't win the case. We just
because
settled.
he settled at mediation. Okay.
But it was a money thing.
So it was a money case. Okay, so if it's a money case, it goes to court, as we said, right? But just because a case goes to court doesn't mean that it's not going to wind up at mediation.
I see.
It absolutely will wind up at mediation before a case sees a trial.
Okay.
Every single civil litigation case in Florida before it's going to trial will be in front of a mediator.
Okay, so
guarantee it, lock it in, right? No case is going to go to trial without seeing a mediator. So the confusion is maybe the case didn't have to start out in mediation. It was allowed to start out in court
because it's money.
Because it's money, but before it sees a trial, it's going to mediation.
And then they settled there.
And then they settled there.
And he did win, though, so he feels he won.
Well, maybe he did,
but he didn't win the case. He settled.
Maybe at mediation, the parties settled with that owner. Right? Not having to pay late fees or interest or maybe attorney's fees.
Who knows what the jury would have done?
And you never know what a judge or a jury is going to do. You never know. So maybe that owner feels that he kind of won in that situation because maybe the association waived attorney's fees or costs or interest or late fees or something like that.
Before you go down any of these roads, try to resolve it, before any of
That is such a no-brainer.
Right?
Of course it should be.
Just come on.
Let's put it this way. Every case, almost without exception, should be settled at mediation if the parties are both reasonable. If even one party is absolutely unreasonable, it's not going to settle. All it takes is one party to be unreasonable, and that's the mediator's job to kind of say to that party,
you're being unreasonable.
You're potentially being unreasonable, and do you realize what can happen to your client if you're wrong, right? So that's the job of a good mediator, to remind that attorney or remind that pro se litigant, you're guessing wrong on this. I know you think your case is strong, but if you guess wrong on this,
it's a gamble.
Let me tell you what can happen. Let me tell you what can happen to your personal assets. Okay, so
I had mediation one time about a painting, and the judge goes, so a woman sued me. I was halfway through the painting, and so I show up with halfway painted painting, and the judge goes, well, don't you want to countersue her for the money, the rest of the money she owes you?
Oh, really?
And I'm like, oh, okay. I didn't know the judge could. I don't know how the judge could pop in there and help me out, and it all went away.
Real, and it went away.
Yeah.
Good, because, well, the judge, in effect, sometimes the judge kind of acts as a mediator,
he did.
Too. Yeah.
He did.
Right. And that's a good judge.
Interesting.
You know what? Let's do this, Rob. Let's take our bottom of the hour break. For whatever reason, not hearing through the old earpiece. Then we'll come back. We'll take your calls. So keep the calls coming in. 717-452-9378. 717-452-9378. Or drop us a question or comment in the chat box on YouTube. Back right after this.
In South Florida, the transition from bright sunshine to heavy rain and hurricanes can take a toll on your property's exterior and structural integrity. Cracked stucco, spalled concrete, they're more than eyesores. They can signal deeper issues. Now, with new Florida laws involving structural integrity requirements, we want to help you meet your milestone inspections and maintain the durability and beauty of your building. Since 2004, PD has been the trusted expert in structural concrete restoration, painting, and waterproofing for condominiums and commercial properties. Visit pd-concrete.com or call us today.
All over the world, people have plumbing problems. These problems can be expensive and destructive to fix. Have you ever wondered if there was a way to take care of your plumbing problems without destruction and an outrageous price tag? Welcome to Pipelining Technologies, Inc., where we specialize in fixing your problems without demolition and minimum cutting by means of pipelining. Pipelining is the ability to take a pipe damaged by root intrusion or long-term deterioration and make it new. By means of inserting an epoxy-saturated liner into the pipe and allowing it to harden or cure, leaving behind a brand new pipe.
That sounds great. How can I get pipelining in my home, commercial building, or condominium?
Simply fill out our online contact form and a pipelining representative will get in touch with you in a timely fashion, or call us directly at 561-853-5463.
Welcome back to Condo Craze and HOAs. Oh, we're in the second half
Here
hour
we
already.
go.
We've been
Yep.
just yapping
Goes
the whole
fast.
time. Go to the phones, right?
Yes, we can. Absolutely. Let's go to the phones.
What we got?
All right, to our first caller in Bay Harbor, Melissa, you're live.
Hey, Melissa.
Hey, Melissa.
Hi, good morning. How are you?
Morning.
Good.
How can we help?
Hey, really quick. So, we recently did an audit, right? Because we've had people that have moved into the building for the last 10 years, a lot of non-compliance, different things, right? But we have, because we don't have people that want to volunteer on the board, we're kind of forced to just kind of take the people who sign up. One of them happens to be an investor, second home owner, that also lied on his screening application. I'm not going to go into that. But, and of course, we found out afterwards. And it has to do with occupancy in a one-bedroom.
Okay.
And then he actually went ahead and he did a remodel. He pulled permits. He didn't pull permits to replace the main door entrance. So we don't see that on the permits. But he also changed the locks. And he doesn't have like that digital lock. It's another type of lock that it's like, you put in a code and stuff like that,
Okay.
but that lock's still not, like in Lake County, right? It doesn't show, it can be a hazard. So we did an audit and we're 28 units and 26 units replied confirming or validating whether they did or not. And if they did, they provided keys.
Mm-hmm.
Right.
So I have 2 units right now and he happens to be one of them. I mean, and this guy, he's challenging me. I've been in this building for, 20 plus years.
Right.
I've been on the board several times. I'm the board president. And he is like, no, like, I'm not going to give you a key.
Okay, so let me give you an answer on
And
that.
because of the same thing that we don't have enough volunteers, nobody also wants to sign up for a compliance committee.
Right.
So we don't have a choice but to escalate this through a vote to the attorney. I just kind of want to see exactly like we're doing the right thing.
This is the exact type of case that goes to arbitration right off the bat in a condominium. I can't tell you how many arbitrations decisions there are on this exact issue where the governing documents, I'm assuming your governing documents requires a key, or
You
the
have
rules and
to.
regulations
I mean,
require a
Yes.
key. So
Yes.
there is, to cut to the chase, there is absolutely no excuse basically whatsoever that this person can come up with that would prevent him from having to give a key to the association.
But he's on
End
the
of
board. He
story.
can say, well, I can
He
get
also,
in.
by the way, he also says it's because of Sabbath.
Because of Sabbath?
Yeah.
I have no idea
Also,
what
well,
Sabbath
he's
would have to
bringing
do with
religion in.
it. I can't see
Yeah,
how
he's bringing
religion would have
religion in.
anything to do with this. Any day of the week, if there's an emergency in that unit, if there's a flood, for example, and the board needs to get into that unit, a fire, whatever it is, right?
They'll break the door down.
Yeah, I'm telling you, that's going to be a losing argument That's going to be a losing argument not to leave a key. And not only is that person going to lose, they're going to wind up having to give you the key, and they're going to have to also pay your attorney's fees and arbitration costs. And
will he have to change the lock that it conforms a whole lot more to something that is accessible?
If your governing documents require a specific lock, then the answer is yes. I don't know what your governing documents say.
Because he could change the code every day.
True. I'm just talking about situations where the documents require that the board has the right to have a key. You don't leave that key, you're losing. You're going down on that fight.
If it doesn't say anything about digital,
if it doesn't say you have to have a specific lock, no, but if it specifically says you have to provide a key, then I'm going to assume that you have to have a lock with a key, or at least you got to provide the combination.
Yeah, he said that he's giving us the combo and stuff like that, but there are no guarantees, you know.
Oh, he is giving you the combo.
Well, he's going to give you the.
It's not like the kind of lock. Yeah, this lock it's a hazard.
Right. Well, again, and there may be some cases out there also that if his lock looks completely different than the others, may be considered a material alteration. There may be language in the governing documents that say the exterior doors of every unit needs to look the same, meaning
also
the same
if he's wired it into
if he wired it in, we don't know exactly right. We don't know certain of the issues I can't answer without seeing your governing documents, but just, you know, as an overall premise, if the docs require that somebody leave a key to the board for their unit, if they don't do it, they're going to lose.
Yeah, I think the code is, he can change that. You're in Ball Harbor, right?
We have others with digital codes, and they've provided both the code and the key.
And the key, there you go. Okay, well, that's what he should do. Okay, thanks for the phone call.
Thank you.
Who's up next, Rob?
Appreciate it. Thank you.
You got it.
All right, let's go to Marie in Fort Lauderdale.
Hey, Marie.
Hey, good morning, Eric. Good morning. Hi.
Hi.
First, I wanted to tell you what a great job you did at the HOA board certification class a couple of weeks ago.
Thank you so much.
I got my certificate. I don't know how you did it all those hours.
I appreciate standing for 4 hours. Yes, somebody's got to do it, right? I really appreciate it. I'm glad you enjoyed it.
With Fort Lauderdale. Yeah. Also, I wanted to know, are we going to get slides? I think you mentioned that you're going to forward slides.
Absolutely. We send the copy of the presentation to everybody. Give my office a call tomorrow, and we will make sure that you get it. Okay?
Okay. All right.
It's also in the email that you got.
You already got it.
I Googled when Kaufman language was instituted, and it was back in 1977.
Yeah.
So I got on the board last week, but I'm only an alternate. Unfortunately, I wanted to be a board director, but maybe next year. But I asked the management company if we have Kaufman language in our docs, and he said we do. And I'm thinking, geez, these docs are so old, you can't even find them on the website. I don't even have a copy. They're 20 years old. So anyway, he said they're in, don't worry, we have Kaufman language. So I'm walking outside, I'm talking to somebody else, and the president of the board walked by and heard me, and he said, oh, you want Kaufman language? It's going to cost you $30,000 to put it in our docs. And I'm thinking, okay, so if we have it, then why did he make that comment? But then I also Googled, and it said it's maybe upward to 5,000, maybe.
Okay, so a couple of things.
Doc.
So let me answer your questions. Okay, you got two questions. The first one is, why is your manager giving you a response to that question if it requires an interpretation of the documents and certainly requires some knowledge of the statutes and Supreme Court decisions, because that manager might think that the language is in there and it's not. It's got to be drafted in a very specific way, and the manager should absolutely no way, no how be giving the association any advice on whether or not the correct language is in the governing documents, because oftentimes it's very confusing.
And practicing law without a license.
That's what it is. That's what the Supreme Court calls it, okay? Practicing law without a license.
He's not actually the property manager. He's working under the guise of the so-called property manager.
So he's less than the property manager. Okay, so bottom line is...
So he's not...
Yeah. This person,
he doesn't even have any kind of line of authority, really.
Right. Okay. See, the board should not be taking legal advice from this person End of story.
He's a
That's number
know-it-all.
one. A know-it-all, right. Number two, it does not cost an exorbitant amount of money if you only want to do one amendment to your declaration of condominium,
Gotcha.
which is
Okay,
to just
okay.
add Kaufman language.
Which takes what?
We're talking about, I don't know, somewhere in the neighborhood. Let's just say an hour of attorney's time.
But he has a whole vote of the entire
It's
community.
got to be a vote of the community, right? Typically, your documents
Right.
would require, let's say, a 2/3 or a 3/4 vote to amend your documents accordingly. But it does not take $30,000 like your
Okay.
president scared you, tried to scare you into believing.
Well, I'm getting the idea that he needs an attitude adjustment because his opinion is the only one that counts on the board. That's why I'm on the board.
Right.
But I would really love to see us change out our management company, but unfortunately they don't want to because they pay him only 20 hours a week to manage our property.
Right.
And they don't answer any calls, they don't answer any emails, they don't take care of any problems. And they like it because they're only 20 hours and they don't pay them a whole lot of money.
Right.
But somebody represents that property management company at every single meeting.
Right.
So you can't talk negatively about them because they're sitting right there.
You can, if you tell that management company, hold on. Two things, actually. I was going to say you can if you tell them not to show up, but that's not true either. You can talk about them negatively anytime you want to. And quite frankly, if you're a board member, and your management company is not doing the job, you better talk about them in front of them and let them know that they're not doing the job properly.
They work
because
at your
that's your
pleasure.
job,
Yeah.
right? They work at your pleasure. Again, Karen, we always say
Okay.
this. A lot of times the boards have no idea of the
You're in
relationship, of how the
charge.
relationship works. It's
Well,
kind of
actually,
weird.
the owners are in charge, and then the board, and then the manager.
It's really bizarre. It's bizarre.
Okay. Okay. I appreciate your
Thanks
comments.
for the phone call. You
Thanks a
got
lot,
it.
Eric.
The
Okay,
management
bye-bye.
company is an
Bye.
employee.
Independent contractor, but in effect, yes,
You're
that's
paying
correct.
them.
Yeah, you're paying them for a service. That's correct. Back to the phones, Rob.
Over to Delray Beach, David, your life.
David.
How are you, David?
Hello, Eric. Thank you for taking my call.
Sure. How can we help?
Approximately 1 year plus, the board decided to put new dryer vents on the building. Now they're sending out a notice that it's a fire hazard and there's a problem. And who is responsible for cleaning out the vents? The board or the unit owner?
So they're telling you that that it's a fire hazard now.
With the new vents?
With the new vents, right? I'm not 100% sure. They put these vents in, and now they're saying, but it's up to you guys to clean.
Yes.
Is there anything in the governing documents that mentions it one way or the other?
No.
And there were not dryer vents originally?
No, these are different types. The original ones on my unit lasted for 20 years.
Well, I'm going to take the position, if your documents really don't say anything about it, I'm going to err on the side of, since this is located within the walls, right, behind the paint of your unit.
It's the exterior vent. It's on the outside of the building.
No, right, and it's on the outside of the building. It's not part of your unit, right? Then that's something, in my opinion, that the association should be doing, that, the handyman or whoever there is that they hire to do that, that's who should be doing it. And I would do it if I was the association. I do it quickly. Those failure to clean those out could easily spark a fire and create, I don't have to tell you, havoc and potentially death. So rather than fight about it, association, maybe just clean it. Just pay somebody to clean it out rather than wait for the owners to do it. Okay, that's my 2 cents on it.
Here's something juicy.
Okay.
Okay? Thanks for the phone call.
Thank you.
Yes.
Condo, this is Gerald Honeckle. Condo board president calls an owner a liar, followed by want me to share your dirty laundry. This all preceded by owners sharing that their property has a lien by unpaid condo subcontractor.
So the owners lets the community know what's going on.
And
then the president retaliates with, you're a liar, and I'm going to steal your dirty laundry. So needless to say, so it's kind of almost like a he said, she said kind of thing.
Yeah, but if you have a lien.
The president, but needless to say, yes, you're right. If there is a lien and that unit owner is right, if that unit owner is right, okay, well, you know what, let me regroup here. There's a new condo statute that talks about unlawful retaliation, a brand new condo statute.
Ooh.
So what does it basically say? It says the unit owners have a right to use their First Amendment rights right at meetings to address the government with problems about your condominium, to talk to other owners about problems with your community. And in response to that, the board cannot retaliate. So this certainly seems like an example of the board potentially retaliating with threats. So this type of situation seems to me that this unit owner may certainly have a cause of action against their board for violation of the statute, which is retaliating for exercising your First Amendment rights.
Arbitration, mediation, court.
We're going to court on that
We're
one.
going to court. Call Eric.
Yeah, we're going to court on that one, definitely.
He called him a liar and says, I'm going to share your dirty laundry.
Welcome to the world of Condo Craze and HOAs,
Exactly, right up our
right?
alley.
Let's take our final break of the hour. Keep the calls coming in, 717-452-9378. Back right after this.
When you need a plumber you can trust, you want to feel safe, comfortable, and never awkward. At Better Call Steve, we fix leaks, not expose cheeks. No crack plumbing, just solid professional work. From kitchens to bathrooms, our team shows up clean, respectful, and gets it done right the first time. So if you've got a leak, a clog, or a drain that needs attention, call Steve today for a free drain inspection. Better Call Steve, 954-50-STEVE.
We are DMI Paving and Seal Coating, Florida's parking lot experts. We specialize in asphalt paving and repair, including pothole repair, seal coating using JC7 or polytar, concrete curbs, ramps, and walkways, and striping and pavement marking, as well as ADA compliance. We service commercial properties, including homeowners associations, apartment communities, shopping malls, warehouses, stadiums and arenas, and more. Experience is worth more than anything in an industry like ours, and our staff has decades of it. We have specialized equipment for any job, regardless of size, saving you time and money. DMI has a reputable history. We have been in business since 1956. We serve the state of Florida from 6 locations. Let us bid on your next parking lot project. Visit us online at dmipavingandsealcoating.com.
Welcome back to Condo Craze and HOAs here on our YouTube channel. And by the way, this is our last 15 minutes. Don't wait to call in. We got a ton of calls. By the way, don't forget to subscribe to our channel. It helps us out a lot.
Absolutely. And tomorrow, for those of you in Orlando, I'm traveling to Orlando actually to teach on Tuesday, the final one of the segment, for a while. We'll be off for a little while until like September or October.
Okay.
Yeah, so we're going to be off for the summer.
Good.
But we'll see you in Orlando, 8 o'clock in the morning on Tuesday at the LNL Condo and HOA Expo. Again, in Orlando. If you haven't signed up yet, there is still time to do so. Just go to the CondoCrazeandHOAs.com website, and we look forward to teaching you on Tuesday. I'm going to take just one question from the board that asks, what's the difference between the condo declaration and the bylaws? So the bylaws is a very, very specific document that tells you how you act as a corporation, meaning it tells you the name of your corporation. It tells you where you hold your annual meeting, where you hold your monthly meetings, if you're supposed to have monthly meetings, how many people are supposed to be on your board, what the officer titles and positions are, what their responsibilities are for those positions. In other words, it tells you how you function as a corporation. That's your bylaws.
And Kaufman wouldn't be in
It
there.
has nothing to do with that. That's exactly right. Your Kaufman language would not be typically found in your bylaws. Definitely not. This is how you act as a corporation. Now, the documents that most of you deal in, day out, especially if you're on the board, that's your declaration of condominium if you're in a condominium. And if you're in an HOA, it's your declaration of covenants or covenants and restrictions. And the declaration courts refer to as the association's constitution. Right? So in there, you're going to find what are the boundaries of the common areas, what are the boundaries of the units, who's responsible for what type of repairs, what about the sales and lease provisions, what kind of pets can we have, if any, and how many, right? The things that you deal with day in and day out, parking restrictions, that's found in the declaration of condominium.
And
that's the difference between the declaration and the bylaws. The bylaws tell you how you act as a corporation, how the company acts.
And the deck for condos has to be preserved after 30 years?
For HOAs, within 30 years, it's got to be preserved. If it's not, it could be gone. Okay. Yeah, everybody freaks out. I've got to tell you, we taught that last week, and a lot of people flipping out, and they go back and they check it for the first time, and they're like, uh-oh, yep. So check it. Okay, back to the phones, Rob.
All right, let's go to, looks like Winter Haven. Meg, you're live with a mediation question.
Ooh, I hope she's coming to your seminar.
I hope so.
Thank you.
Good morning.
We recently had a mediation, which resulted in, it appears that there was some type of settlement. And I'm wondering if we as homeowners are allowed to know what the end settlement was.
Oh, that's a great question. Says sometimes the parties to a mediation, when it involves an association, will try to do a confidentiality agreement of some kind. And I have to say, wait a minute, the minute that this agreement is put to writing, and it has to be put to writing, that agreement in and of itself can be seen by any member of the community.
So the content of the mediation is privileged, but
what you say there, correct. The settlement agreement itself can be seen by anyone and everyone who is an owner in that community. You have a right to know how your association settled that case. Okay.
And if no settlement was reached,
right,
are we allowed to know that also?
Yeah, absolutely, sure. You should be allowed to know whether or not a settlement was reached and what's the next step. Are you in the middle of a court case? By the way, if you are in the middle of a court case, you can check that online. You know, there's no secrets to that. The clerk's office for the county that you're located in will show you exactly everything, paper by paper, as to where your case is at. And if it didn't settle at mediation, there will probably be something filed by the mediator that said that the mediator declares what's called an impasse. And if an impasse is declared in the case, that means the case continues forward on towards trial if necessary. Okay.
So the mediation occurred on February 18th, and there's nothing in the court file other than the notice of the mediation.
And is the case dismissed yet? Probably. If you're telling me it's not, and the
case was dismissed.
It was dismissed
because it was filed without mediation.
And there you go.
There's our topic.
It was referred to mediation. So the mediation occurred. There was a notice of mediation in the court file, but that was on the 18th of February, and there is no further anything in the court file.
Okay.
And the board refuses to disclose what happened.
I can't tell you. If I was someone that lived in the community, I would write. This is a condo or HOA?
It's an HOA.
HOA.
It's right up, yeah.
You can't even ask for what's called a unit owner inquiry. Another example where it doesn't make sense. In a condo, I would say write a letter to the association saying this is a unit owner inquiry. Did the case settle at mediation? Right? You're not asking for confidential
Why doesn't she just ask for the settlement?
She can ask for a copy of the settlement.
Yeah, and then if they say we don't have it, then you'll know.
You can, absolutely. That's one way of doing things. That's right. How about asking for a copy of the settlement if it exists?
Yeah.
I don't know
I've asked and they've refused.
Did they tell you that it's settled, or they're just not telling you one way or another?
They didn't tell me anything.
Okay, if it's settled.
Their attorney sent me a response saying it's confidential.
Okay, it's not confidential. If there's a settlement document where both parties signed, that document is not confidential. That is an official record of the association. You are entitled to see it. End of story.
Does that go to arbitration?
They don't want to give it to you. In an HOA, that would probably have to go to mediation first.
Okay.
Okay?
You got to go to mediation over the...
with a mediation. Or with them to failure to... Did I got to tell you if your own case settled?
Yeah.
See that? Oh, God.
So confused.
Right, exactly. Okay, how about go back to the phones?
Thank you.
Bye-bye.
Bye.
All right, let's go to Marcia and Boynton Beach.
Hey, Marcia.
Hi, I live in an HOA, and on the door of the HOA office, it says the premises are under video and audio surveillance. I don't want to have an audio recording of myself. Is it legal for me to ask to not be recorded?
Interesting question. So on the research that I've
Florida law,
done on this, right? you can't be recorded without your consent.
Correct.
But I've never seen anybody go into a situation where they knew that they were being recorded in that type of a public setting,
Right.
and say, I don't want to be recorded, shut it off. Do you probably have the right to do that? I think the answer would be yes, if while you were in there you said, I don't want to be recorded.
But you don't have an expectation of privacy
No, yeah,
there like you would on a phone.
Right. But you still have to be recorded, your voice, with dual consent in Florida. So I think if you walked into that office, I'm just thinking it through, if you walked into that office and said, I see you're recording voices, I don't want you to record my voice. I have no problem if you took pictures of me, took the video of me, but I don't want my voice recorded. I think they would have to shut it off. I do, because I think you have a right to be there, just like any other owner. And if you don't want to consent to you being recorded with your voice, I think you win that.
Boy, talk about a nanny state.
Yeah. But it's an interesting question, and I think though, when I think it through, I think you win it. Okay. I think she's gone.
She didn't want to be recorded.
That's what it was. Back to the phones.
Let's go to Central Florida, Juliet.
Juliet, how are you?
I'm fine. How are you? Thank you for everything that you do. I have a question. So
Sure.
we have a master association also. We're townhomes. And I am on the board for our townhome section. And I've been asked if I would like to be a board member for the master subdivision.
Okay.
And I'm calling to see if that's something that I can do or cannot do.
Oh, absolutely.
She
That's
can be on
pretty
both
common.
boards?
Yes, can be on both boards. It's very common where the governing documents of a master, let's say there's 5 subs, that the governing documents of the master say that the president of each sub automatically serves on the master board composed of the 5 people.
Even if it's an HOA?
If it's HOA, that even if the master board will usually be an HOA.
Yeah, over
Absolutely.
a condo.
Over a
Yeah.
condo, yeah. Typically, that's how it works. Where the master is typically an HOA. But yes, very, very common that the presidents of the sub serve on the board of the master. Very routine. Or sometimes the alternative to that is that the subs have their own board of directors, and there's also one person nominated or elected, I should say, to serve as a representative towards the master board.
And that would
one
be helpful.
Of the two.
Because you know what's going on.
Yes, of course. No, absolutely.
Just makes sense.
100%. Does that answer your question?
Oh, yes. Thank you so much. I
Okay,
appreciate it.
you
Have a
got
good
it.
day.
Good
Take
luck.
care. Thank you.
Why would anyone want to serve on 2 boards?
I
What a
know, that's
glutton
like
for punishment. My
compounding the
God.
problem.
Back to the phones, Rob.
All right, let's go to Mike.
Hey, Mike.
Hey guys, love your show.
Thank you.
I am involved in a lawsuit.
Oh boy.
I was elected to the board. I ran on a platform to stop the self-dealing of board members, especially board presidents. I live in a COA, I should say. Now, I was trying to take care of a situation where ground floor unit owners in the 2-story condos are building patios, putting fences around the patios, claiming you can't go on the patios.
Right.
So the board sought to have me removed, but they just removed me from the presidency, which I was president.
Right.
Right, you're still a director.
So I filed I'm not a director anymore.
How are you not a
This was
director
3
anymore?
years ago.
Okay, now you're not a director. Okay.
Yeah, I'm not a director anymore. But I filed a lawsuit. I went to mediation, felt that mediation was really a joke. The mediator didn't really do anything, just kind of went back and forth to our rooms.
Right.
And my question is really this. If I was to decide at that mediation that to hell with the Florida statutes, to hell with our declarations and bylaws, and resolved it in violation because they foreclosed, by building these patios, they foreclosed the access to that common area property by other owners. So if I was to settle it at mediation, I'm changing the Florida statute and our declarations and bylaws.
As to yourself, you're not, anybody else that lived in that community would still have the right to potentially challenge that they're cut off. In other words, your settlement at the mediation, it affects you. You're not settling on behalf of anybody else. So you want to waive your rights to go on common property that other people have taken? That's up to you if you want to do that. But by you settling your case, you're not saying that your neighbor can't sue for the same thing.
Yeah, why are you the
just
only
sued
one
for.
that's taking this on?
Yeah.
They're violating their own documents by.
But by you settling doesn't mean that you locked everybody else in. That's your cause of action that you settled. It does not affect anybody else. Okay?
They cut down my tree in my condo yard.
Yes.
I really don't. I understand I'm settling for me.
Yes.
But now the patios are going to be built against, they took a vote. They got the 2/3 vote to change our declarations. But by law, you need 100%. If you're going to foreclose common area property,
And that's probably true. And not only that, you might need a vote of the mortgagees in that condominium as well. I agree with you. But
and it's also in our documents.
okay,
it's
but
also in our
so
declarations. That's
anybody else
basically written.
hold on, anybody else can challenge that. They're not precluded from challenging that just because you settled your one case. Okay? You can tell your neighbor, go file suit right now. Okay? On that note, Rob, we got to take one more.
I'm still filing the lawsuit.
Oh,
we
well.
didn't settle.
Okay. Wish you luck.
Knock yourself out.
Yeah, thank you.
All right. Who else we got, Rob?
All right, let's go to Kathleen in Hallandale.
Hey, Kathleen.
Hello.
Hey, Kathleen. Good morning.
Good morning. I'm calling. I live in a 55 over co-op, and when you sell your condo here, you have to pay cash. My neighbor had a buyer. She's in her 80s. She used to be on the condo board, and it has to go through a screening. During this screening, they had recorded it, which I've never heard of that before. Now, the woman who was selling, she used to be on the board, and some of the members now, they have conflicts, and we have this woman who works in the office 20 hours a month, and they're letting her put input in also. So anyway, this couple wanted to purchase the condo. They were paying cash, the co-op, they were paying cash, and the board, some of the board members and this woman who works in the office denied them because they said that the couple, the female, she had a little bad credit. The man had great credit, and this woman still works also. So they offered to pay 1 year in advance, the HOA, and they refused. So, and then they also made a comment like, what if something happens to the man, he dies, how's she going to pay for her condo, her co-op fee? Just wondering if my neighbor has any help to, any.
I don't know what your governing documents say. If they even have the right to screen, approve, or reject. A lot of times board members think, because I'm on the board, I have a right to screen, approve, reject anybody that wants to move in here. That's absolutely not the case.
All cash is all cash.
Right, but that's separate. You have to first start with, does this board even have the authority to screen, approve, or reject the people that want to move in? Just because you're on the board doesn't mean that you automatically have the authority. The documents have to give the board the express authority to approve, deny, interview, the whole deal. You can't just assume you have that right. Now, you just said something about all cash, right? I tell clients all the time, if somebody is moving into a co-op, right? How much are these units going for, approximately?
They were paying $130,000 for a one bedroom.
Okay, so this person is putting $130,000 down cash, right? And suppose they don't pay. Are they really going to lose
the whole thing?
The whole thing, a few months of co-op assessments every month?
They're not going to let him in because he might die?
Right.
That's not even a
Silly.
reason.
Right. And I also took the position many times that if a bank is willing to loan financing, then why shouldn't the association, give financing? But certainly here, if somebody's paying cash, do you really think someone's not going to pay the association, and when they don't pay, get foreclosed on? They're going to lose their $130,000 in equity for not paying a few months of assessments? Silly.
Sorry. And also, after they were giving them a hard time, the couple offered to pay 1 year in advance.
Right.
The HOA fee to pay up, and they still deny. See, they particularly, this woman that I'm talking about is selling a place. She's in her 80s, and she was on the board before, and she always questions them, and they don't like that. So
Right, I get it. What's my personal opinion here? Number one, I'd want to see what the documents say, right? That's number one.
Okay.
Do they have language in the governing documents that say a person must have a minimum credit score or not, right? I don't know. Does it say that in there?
She's not even the main person.
Well, if she's going to be on title, if she's going to be on the stock certificates, we need to know.
All right.
Right. If it's a co-op, you're going to be on stock certificates. So I need to know that. Need to see what the governing documents say. But bottom line is, if someone's putting down all the cash, the association should not have a problem with them moving in. It's really not a risk at all. Very, very, very minimal risk. And the fact that they wanted to put up a year of assessments in advance, then it's really not a risk. Okay?
Okay. So what could she do, my friend?
Can't give you that answer until I actually saw the governing documents, because I don't know what they say. Depending upon my review, I may say it's a great. Don't tell me if they say. Forget that. I wouldn't. I don't want to give.
I know the condo doc does say right of refusal.
Right. Now that's another thing. If they reject somebody, right, must they purchase? Do the governing documents say that if they reject, they have to provide an alternate buyer? I don't know if it says that. Many documents say that. Okay, so there you go.
It does say that.
So they may have to provide an alternative buyer, or they have to buy it themselves. But I can't tell you.
That's what it says.
Okay, there you go. So I was right on that. That's one in a row. See that?
You have two in a row
Two in a row now, Winnie. It's a good day.
Just one other quick question. This woman who works in the office 20 hours a month, does she have a right to be involved in this situation?
Probably not. Of course not. Only the board makes that decision. Okay?
Okay.
Thank you.
Perfect. Thank
All
you
right,
so
you got
much.
it.
I
Thank
appreciate
you.
it. Take care now.
You got it.
Bye-bye.
All right, that brings us to the end of the show. I will see everybody Tuesday in Orlando. Look forward to teaching everybody. And of course, if you need legal help off the air, give Glazer and Sachs a call. 954-983-1112. Again, 954-983-1112. Wishing all of you and all your families a wonderful, happy, healthy week. And we'll see and speak to you again next Sunday at 11 a.m. on Condo Craze and HOAs. Be well, everybody.
Thank you. Say hi to me.
Same truth, same time, no smoke, no spin. See you next Sunday at 11 a.m. You've been watching Condo Craze and HOAs. Lights coming down, another hour gone. Hard truths, lines clearly drawn. Process matters, rules come first. Ignore them once, and things get worse. Read the rules, show up in fun. When mistakes happen, don't take it personal. That's how lawsuits fade instead of grow. That's how communities stay in control. We take the calls, we hear it all. Helping Floridians stand tall. Condos, HOs, every voice has a place. When you face it head on, chaos loses the race. Same truth, same time, no smoke, no spin. See you next Sunday at 11 a.m. You've been watching Condo Craze and HOAs.